Welcome to part two of Chapter 9 Intellectual Property from the Legal and Ethical Environment of Business by Terrence Lau and Lisa Johnson. And this is Dr. J. Kent Gregory. And let's begin. We'll be talking about uh, trade secrets and trademarks in section two. So, a trade secret is anything of value a company takes reasonable steps to protect from disclosure. So these could be things like the recipe to Coke, Coca-Cola. It could be algorithms, for example, that Google uses or other companies use. So if someone uses lawful means to uncover the secret, then the secret is no longer protected by the secret's owner. So a great way to do this would be through reverse engineering, and we mentioned this in part one. So trade secrets are secret information that can include things like the process, the formula, a pattern, a program, a device, method, technique, compilation. I guess under compilation one would consider recipe. So the Uniform Trade Secrets Act, so the UTSA, kind of spells out some protection here. So the secret information drive to be, trade secret. Secret information drives actual potential economic value from being a secret that is not readily discovered by others. So, for Google, you have these search algorithms that are not readily imitated or discoverable by others. Or if you're Coca-Cola, you have this recipe that's set you apart from your competitors. Most states have adopted the UTSA, but not all have. And unlike patents, trademarks, and copyrights, there's actually no broad federal law protecting trade secrets. So misappropriation. This is appropriating wrongly or without justification. So in our case here, a claim for misappropriation will be brought when a trade secret has been wrongfully obtained. So, for example, through corporate espionage or bribery. And damages will include the actual loss plus the unjust enrichment not captured by the actual loss. And in cases of willful or malicious misappropriation, double damages. So double damages may be awarded and attorney's fees. So key takeaway are trade secrets actually last forever if the owner of the secret keeps the secret. However, if someone else discovers the secret through a lawful method, then the owner of the secret has no right to exclude others from using the secret. Trademarks. So a trademark is any logo, mark, sound, or other identifying characteristic that signifies the unique origin of particular goods or services. So a trademark is valid as long as consumers rather, believe that the mark is associated with a specific product or a specific origin. So the trademark doesn't need to be registered with the government for this validity to exist, but it's a good idea to do that. The Lanham Act, this is the federal law that protects trademarks, and all brands are trademarked, but not all trademarks are brands. So McDonald's is a brand, and it's a trademark. When a trademark is recognized, it's typically for a specific category of goods. And so trademarks can go beyond simply a company's name or its logo. So, for example, trade dress. This is the distinct and unique look, feel, or shape of a product or service that signifies its unique origin. The service mark is a trademark for an entity providing services as opposed to goods. Certification mark or certification trademark is a trademark representing a good or service meeting minimum standards established by the owner of the certification mark. A collective mark, or the collective trademark, is a trademark representing membership in a group, for example, the non-GMO group, or natural products. I'm making things up right now, as established by the owner. So the Lanham Act Lanham Act, it excludes a few categories from trademark registration. And this is mainly for public policy purposes. So trademarks aren't going to be granted if they're similar or identical to a trademark already granted. That makes sense. Also, and this sort of makes sense when you think about it, trademarks cannot contain the US flag or any government symbol or anything immoral. And trademarks cannot be merely a geographic indicator. This is a system whereby names for products, especially foodstuffs, are reserved exclusively for products originating from a particular region. Now, this finds its ultimate expression, particularly over in Europe, when one thinks of wine classifications. Although wine classifications, for example, still do exist I mean, not still do exist, but they've become increasingly more popular and ri rigid, I suppose, in the United States, for example, in California and Washington. Uh, and a trademark is valid as long as consumers believe that the mark is associated with a specific producer origin. Then there's this thing called genericide. This is a former or claimed trademark indicating the general class of goods, not eligible for trademark protection. So, great example of this is Kleenex. Well, Kleenex was originally a trademark, but when you and I mention Kleenexes, it just typically generically, means any kind of tissue, even kind of like the no-name tissues that one can get at Kroger's. Same thing like in the South, where a lot of people call anything that's a carbonated beverage a Coke. Uh, so Coke in the South has become genericized. Uh, Trademark infringement occurs when someone uses someone else's mark, either completely or to a substantial degree, without the permission of the mark's owner. And the law permits owners to sue infringers who use their marks to a substantial degree. So, these are like these, rip off Gucci's or rip off, Rolexes, those kind of things. And that's been going on forever. One only needs to think about the Ulf Bert, I think I'm spelling this correctly, the Ulfbert sword, the Viking Ulfbert sword, which uh, there were knockoff Ulfberts. Uh, so there's so there's the concept of dilution. So the use of a famous trademark in a manner intended or designed to cause tarnishment of the mark. And dilution permits a trademark owner to stop usage of a similar word or phrase, even if consumers aren't confused. And a trademark owner only needs to show that its mark will be diluted or tarnished in some way. Uh, the Federal Trademark Dilution Act is it's somewhat controversial because many felt that Congress had gone too far. Congress had failed to clearly define dilution, and the Supreme Court ultimately ruled that to win a dilution case, a trademark owner had to show that it had suffered actual economic damage, not the likelihood of damage. So now, through the Trademark Revision Dilution Act of 2006, trademark owners of famous trademarks only need to show a likelihood of dilution before filing a dilution lawsuit. Um, Companies or persons accused of trademark infringement have several defenses. So one is argument that no infringement has occurred because the two marks are sufficiently different that consumers won't be misled. Then there's fair use, the right of the public under certain circumstances laid out in copyright and trademark law to use protected intellectual property without permission. So, for example, copying portions of books, articles for academic purposes. The Lanham Act prohibits the use of someone else's trademark when selling goods. And then the First Amendment recognizes the use of parody, comedy, or satire as fair use. So to round out trademark discussion, there's also cyber squatting, which probably a lot of you all have noticed if you've tried to, register a domain. And this is where folks have gone in and registered internet domains for the sole purpose of selling the name to actually its rightful trademark owner. So they've got, jumped the gun on corporations. And then there's the Anti-Cyber Squatting Protection Act. It's only illegal if the domain name is registered to make a profit through later sale. It's not illegal if someone registers the domain name in good faith. And the First Amendment is a defense to cyber squatting. So three right there. So that wraps up part two.